The first article is regarding right to free and compulsory education, basically annual status of education report, rural. This 2000 has revealed certain outcomes regarding that how the right to education is working, and it has revealed certain things and it also recommended certain things. And one of the major recommendations of this report is that right to free and compulsory education, which is under article 21a, fine, 21a fundamental right is talking about right to education. So but under 21a, it's about for the like free and compulsory education to all the children between the age group of 6 to 14 years of age. But this report is saying that this right should be extended to the age group of 14 to 18 years of age group children as well, because this is a very vital age, fine, and this is the age which basically shapes the children for the coming future and for the coming economic and employment opportunity. And so this age group is critical for India to reap its demographic dividend. This is the essence of what this report is suggesting. Fine. Apart from this, it is saying that 14% of this age group, which is like 14 to 18 age group, fine, 14% of this age group are not enrolled. And when this age group will come as a workforce, fine, in their 20s, then it is going to be a huge cost for India. That means around 14% of at that time youth will not be able to have employment proper employment opportunities, fine. Apart from this, this report is saying that a very less percentage of this children in this age group are gaining this attaining vocational training from vocational courses. And within this 5% also, the children which are having this vocational training, their retention is quite less, only for a period of 1 or 2 months, at max 3 months, fine. Other apart from this, other revelations of this annual status of education report is that the learning outcomes of the children are quite low. They are shockingly low. That means only 43% of the youth could solve a arithmetic problem involving division of a three-digit number by a single digit. And apart from it, there there can be enrollment ratio, there can be increase in enrollment ratio, but their learning outcomes are low, and their attendance in the school is also low. Okay, so the first thing is that learning outcome, oops, what it is, learning outcomes are low, and apart from that, attendance, or one can say retention, is also low. Then this report is saying that there are discrete differences among states on the number of youth who are not on the rolls in appropriate levels of schooling. That means that state-wise variations can also be seen with respect to the number of youth who are enrolled in the school. For example, like there are contrast variation between the enrollment percentage of boys and girls in Chhattisgarh and if we compare it with Kerala, fine. And this, so state wise variations are also there, plus there is digital divide. How digital divide? See, it's saying that 61% of respondents have never used internet, and 56% have never used computers. But the irony is, or the interesting part is this, that 73% of the youth, they are having accessibility to this mobile telephony. And it's not a part of article which I'm going to say right now, but the thing is that this mobile telephony can also be used as a tool in imparting education or vocational skills. It's apart from the article, one can use in the answer or in answering something. So there are state-wide wise variations, and there is gender-wise variations also, because girls were worse off in terms of access to computers and the internet. So the report is suggesting that government should make expenditure on good education, because good education is bound to have a multiplier impact on effect on productivity, because if our children are having good education, vocational training, in future they'll be having more employment opportunities, and when more number of youth are in employment, then definitely the economic productivity is going to increase. So this was the first article. And next is regarding, as we all know, that four judges, they come into the public, and they said that the Chief Justice of India is assigning cases on based on his preferences and sidelining certain conventions. This article is talking about this only, and it's saying that there is a need for judicial reforms. Now, what sort of judicial reform this article is talking about, we need to look at it. The first thing, see, it's very simple. This entire para, which is shown in picture, it's saying that there is lack of transparency in the judiciary. It's a well-known fact that there is lack of transparency in the judiciary. Now, see, they're saying that one possible answer lies why this all has happened, why there is arbitrariness in the this conduct of Chief Justice of India. Fine, why this arbitrariness is now in the public. Fine. So they are saying that this is because the answer lies in the opaque nature of the judicial structure. Fine. The opaque internal structure of the judiciary. This is the reason why this kind of discretion and why this kind of preference based assigning is being done. And at the time of constitution formulation, B.R. Ambedkar, he said that no matter like how much upright the CGI will be, fine, but there should be no absolute power vested in him. So these were the views of B.R. Ambedkar. And here in this paragraph, it's saying that we have basically adopted this convention of Chief Justice as a master of the roster from England, and in England as well, there have been occasions where political interference has been seen in the conduct of the Chief Justice of England. So they're basically just telling that thing, so it's not that much important for us. Now the second thing is, as we know, that lack of transparency. The second thing is that fears of politicization. They're saying that judiciary has always been denying that regarding judicial reforms and all, citing one important excuse, that there will be a politicization of the judiciary, or there will be interference from the legislature, and so the independence and independence of the judiciary will be at stake. Fine. So this is all about that. Next is and one thing more, that judiciary has always cited this emergency whenever there are talks for judicial reforms, or whenever there are talks for involvement of legislature into judiciary. For example, the National Judicial Appointment Commission bill, it was basically became an act, but judiciary termed it as unconstitutional, citing that it is a violation of independence of judiciary, and violation of the very basic structure of constitution. But judiciary is citing these things, and time and again citing the example of emergency, how at the time of emergency in 1970s, the independence of judiciary was curbed. The judiciary has been using this particular excuse time and again. Fine. So this was all about that, what are the different reasons and what excuses judiciary is trying to give. But the writer is trying to say that it's the high time that we need a Supreme Court Act. We need a act on Supreme Court. Fine. The writer is saying, although there are news that internal resolution is going means taking place between the Chief Justice of India and the four judges who came in public, but this internal resolution is just it's a temporary solution, it's an ad hoc mechanism, and he has termed it as band-aid solution. It's an ad hoc mechanism, it's not a permanent solution to the this opaque nature and the internal deficiencies within the judiciary. It's not a permanent solution. So what is needed is a Supreme Court Act to be passed by the Parliament after an open public discussion involving all stakeholders. Now, who are these stakeholders? Civil society, judicial members, judiciary itself, bar members, and members from all shades of political opinion. So, it's the high time that we need a Supreme Court Act. Now, the thing is that can this legislature make an act on Supreme Court, because we say that judiciary is independent and there should be no interference from Supreme Court. But yes, Parliament can definitely make an act on Supreme Court, because under this union list, fine, in Schedule 7 there is an entry 77 which mentions regarding the powers of Supreme Court and act on constitution. So definitely it's within the ambit of parliamentary powers that a Supreme Court Act can be framed. Now, it's why now what the writer is suggesting, that it's vital that a court of, we have 31 judges at present. So he's saying that a court of 31 judges, if it is to be function as an apex court, so certain degree of institutional coherence is required. Why coherence? Because we are seeing that four judges are saying something else, Chief Justice of India is doing something else. So the entire institution is not going in one particular line, fine, in one particular direction. So we need institutional coherence, and for this he's saying that we need restructuring of the Supreme Court into three divisions. So basically the writer is suggesting that the structure of Supreme Court should be reframed and it should be divided into three. One, two, and this is three. Now what are these three divisions? The first is the admission division, then we have appellate, and then we have constitutional. Now see what this admission division is going to do. We all know about special leave petition under article number 136. So this admission division will first scrutinize all these special leave petitions and will then decide that which of the petitions needs to be admitted. Fine. So this is the work of the admission division. Now then we are talking about constitutional division. This one thing more, that see we are having 31 judges, and under this admission division we'll be having how many judges? We will be having 5 randomly selected judges, and they will be acting on this admission division for 1/4 of the year only, and then their division will be switched. Fine, their division will be switched on to other ones. Now second is the constitutional division, and this will be a permanent constitution bench, fine, and consisting of 5 senior most judges of the court, fine. So 5 and 5, we have 10 judges out of 31. 10 are there, work has been assigned to them. Now 21 judges are left. Now we are talking about third division, which is appellate division. Now what this division will do, that they will hear all the matters which the admission division has admitted. Fine, we talked about admission division, which the work of which was to admit the special leave petitions. So whatever the special leave petitions were admitted by this admission division, appellate division will hear on that. Fine, and any other matter, any other writ or appeal which lies a matter of right to the Supreme Court, that will be heard by this appellate division. Now the writer is saying why this restructuring is required and what all benefits it's having is, the first is it will bring coherency in the jurisdiction, because see we have assigned judges, we are having permanent constitutional division, so on all the matters which are constitutional in nature will be having a kind of coherency, fine. And then the appellate division is going to hear all those cases which already the admission division has scrutinized and admitted. So there will be no kind of incoherency will not be there. Second thing is that it will allow more contemplation of which matters actually deserve admission, because admission division is basically scrutinizing after a deep contemplation that which all matters should be admitted or not, fine, which needs to be admitted or not. So definitely there is a more contemplation. And third, it will reduce the discretion available to the CGI to select benches. So because the whole the problem arises with the four judges accusing the CGI about his discretion, so this discretion will also be limited because we have already divided the benches among the divisions. So this way this discretion will also be limited. So this restructuring will bring coherency. It will give more time to contemplate on the on the matters. And third is it will limit the discretion of the CGI. So the writer is just saying that whatever is to be done, judiciary has to restore public confidence, and public conversation is necessary to underline that the judiciary is a part of all this constitutional framework. And this internal resolution which is right now going on, it is an antithesis of the thesis. Antithesis of the thesis means, see, the four judges coming into the public and this revealing out or telling that how the CGI is working, this is a thesis. Now the solution of it is that they are resolving this matter internally. Now this is antithesis, fine, but this antithesis can only prevent the present crisis, but we need a permanent solution to this problem. Fine. So this was the whole idea behind this article. Now there is one more article which is not basically from the Hindu. It's from Indian Express, but I find it quite interesting. It's a short article. One can just see. Actually, the Supreme Court it said that the CAPS, fine, or the community organizations like CAP, and even the society and the parents, they don't have right to question the marital choice of the person or their children, fine. So it's saying that CAPs have no right to question the marital choice of community members, and the same decision it extends to it must apply to all of society, including parents, fine. And so obviously the now the legislators, they could come with a law so that proper demarcation can be done, that what this, fine, see man, this is the line, beyond this you don't have to cross, you don't have to question their marital choice, fine. So apart from that, they're saying apart from that, it's saying that although many or some of the CAPs, they are trying to embrace the modern and liberal values. And for example, Satrol Khap Panchayat in 2014 permitted intercaste marriages, but they're saying that this embracing of modern values is not because they are trying to be modern or something like that, but it's because of it's a kind of compulsion to them, because they're not having adequate number of girls which can be future brides, fine, for the boys. So the thing is that this all permission to intercaste marriages is because of realism, fine, it's because of compulsion and not because of idealism. It addressed a shortage of eligible brides, the consequence of poor sex ratio, fine. And the Supreme Court is to be applauded for expanding the ambit of its observations beyond CAPS. Why Supreme Court is to be applauded? Because Supreme Court is saying that this particular judgment, this particular thing should be extended to the entire society, including the parents. Because many a times we see that parents and society, they interfere a lot with the marital choice, fine. And up till now, what was happening, that this the administrators and the police, they were not able to intervene in matters like which are related to this marital choice and all, considering the fact that like it's a community member or it's a family member, until and unless an actual crime is committed, fine, until and unless a couple is killed or a girl or boy is killed. So it's high time And even and after this judiciary's judgment, it's high time that legislators should make a law on this. And it's bas, that's it. Okay, thank you.